All right, here we go. Week 12. 10 and 2, 12. This week, we're at the end of the process of trial, and now we're going to talk about the deliberations of the jury going to court and determining the guilt or innocence of the person on trial. So, once they are through with the prosecution and the defense, then they give the instructions to the jury. This is where a lot of stuff happens with the jury because the instructions are so specific that it's hard for the jury to understand how to apply the instructions to the case in point. Because just there's a lot of jargon, just as you guys have learned over the last couple months of what, in these proceedings and things like that. So one of the instructions is on the completion of the closing arguments. In the most jurisdiction, the judge instructs the jury on the law applicable to the case. Just what I said before, right? Instructing the jury is also known as charging the jury. So I want you to watch this video here. 3 things you learned after watching this video, okay? So the instructions to the jury are defense and prosecution recommendations, and the defendant is entitled to instructions being given on all pertinent evidence regardless of the importance. So everything is in the benefit of the defense, the person that's on trial. They're the ones that make sure that all the rights are afforded to them, no matter what type of case it is. So consciousness of guilt. The jury will be informed that the defendant does not have to testify. So because a lot of people are saying, because I know that's how I feel, if I'm innocent of a crime, I want to profess my innocence. Like, hey, I didn't do this, and here's the reason why. But in the law, the aspects of all the law, there is no inference to be drawn if the person does not testify in court. Okay, so if they do testify, that's up to them. If they don't testify, then there's no reference that the person is guilty because they did not testify. Watch this video. Tell me one thing you learned from the video, okay? Comments by the judge. About half of the states prohibit comments by the judge on evidence and credibility of the witness. Because if the judge starts talking about what is present, it could be seen as they're in favor of the defense or the prosecution. So you don't hear a lot of comments about anything from the judge. He only rules on the objections in the case and what's going to be proceeded. So we don't want to say anything in front of the jury, okay? I want you to read in Lacey versus Kirk here and summarize that for me, that what you believe it says in your brain. How do you interpret that, okay? So the deliberations, once they get all the information, they go to the courtroom. And they go to the jury room inside the courtroom, and that's when they start voting. Okay, let's take an initial vote. Who thinks he's guilty? Who thinks he's innocent? And they start deliberating, trying to persuade the other part, no, let's look at this, no, let's look at this, to determine which way they're going to go. They select the 4th person who's going to be in charge of leading the discussions. All right, so they're back in their room. And I want you to watch this video. Tell me 2 things you learned from that video there. 2. So materials inside the jury room, they take their notes because all through the trial, they can sit there taking notes on what's going on. Any evidence they might want to see again, they might ask for the gun to be brought in. They can ask for video. They can ask to be written what was given as far as testimony, and have it replayed back to them, or actually see the written documentation. All right, the length of the jury deliberations. A jury that cannot agree on a verdict is hung. That means it could be hung jury, that one person, 11 says guilty, 1 says not guilty, hung jury. And it's called an Allen charge. So I want you to tell me what an Allen charge is, right? Your understandings. All right, less than a unanimous verdict. To avoid hung juries caused by 1 or 2 jury members, some states have broken the tradition unanimous verdict rules in criminal trials. Some states, not all of them. When the jury comprises of only 6 members, the verdict must be unanimous. I don't know what states right offhand has just 6 people. All right. All states require that the verdict must be unanimous in cases which they have the death penalty. So somebody's going to be put to death 40 years from now, because it usually takes that long to go through the system. Once they're, the death penalty comes, it's got to be unanimous. Everybody's got to vote for that. Okay, so in your state, I want you to tell me a death penalty case. Okay, pick whatever state you have, copy and paste. You guys should already be great at this now, and tell me the death penalty. And I want to know, and then everybody's different, okay? I want you to know if you agree or disagree with the death penalty and the reason why regarding the death penalty, okay? In a bench trial, there's no jury. The judge is the one that decides the verdict, okay? So in a jury trial, the jury decides. Pretty easy peasy. Here's a guy here who was found guilty after he killed a homeless man behind a shop. I want you to read this and tell me, based upon this information, do you think that the verdict was good? Again, you don't have that much information. You got stuff from the newspaper, but I want you to tell me. So, new trial and mistrial. The motion for a new trial may not be made until a verdict of guilty has been rendered. So, a mistrial may be rendered anytime during the trial. Unfortunately for me, I did have a mistrial at one time, and what had happened, there was a case where I found a bad guy. It was a woman in this case, a bad woman, okay? And she was writing a lot of checks, a lot of stolen checks she was writing. And I had found out some information and only had received a name. Well, when I looked up her name, she had a long history of, guess what? Forging checks. Her criminal history is all about forging checks, right? So, based upon that, I thought I'd be good, hunch, put in a photo lineup, showed the photo lineup to the victims, and sure enough, they're like, oh, that's her, that's her, that's her. I arrested her, okay? So when I went to court, the defense attorney asked me, how did you find out this was a suspect in the case? So I told him, based on a hunch, I ran her criminal record. I found that there was a history of forged checks in her past. And bam, mistrial, Your Honor, mistrial got up. Because in court, unfortunately, you cannot tell about the entire history of the bad guy or bad girl in this case. You can't say they've already been arrested and released for murder, rape, robbery, forgery, burglary. You can't do that, okay? But that's how I found it was her, based upon that. So even though that's the truth of the matter, I still was found in a mistrial. So they ended up asking for a new trial, and she ended up pleading guilty the second time. Tell me all about William versus Florida. Here's all the great things that you already learned. Congratulations. That's it for this week. Look at that. Whole 8 minutes and you're done. All right. Talk to you guys later. See you next module. Hang in there a couple more weeks. You're done. Bye.